I'm going to discuss retaliation for engaging in protected activity. Retaliation is covered as 2 of the 13 prohibited personnel practices over which the Office of Special Counsel has jurisdiction. As in all prohibited personnel practice cases, most federal employees and applicants for federal employment are covered under this section of the Whistleblower Protection Act. So let's talk about what is retaliation for engaging in protected activity. Retaliation is the taking or failing to take or threatening to take a personnel action against an employee for engaging in 5 different types of what we'll call protected activity. The first is whistleblowing. I'm going to go into more detail after I cover the other areas of protected activity as to what is whistleblowing. But let's just give you an example. If an employee alleges that their agency has misspent $1 million of agency funds, and thereafter that employee receives an adverse personnel action, such as a suspension, that could fall within the retaliation for whistleblowing category. The other categories of protected activity I'm going to go through now. An employee may not be retaliated against for engaging in an appeal, complaint, or grievance right. Additionally, the third category of protected activity is an employee may not be retaliated against for testifying or assisting another employee who's engaging in that same appeal, grievance, or complaint right. The third type of protected activity is testifying for or making disclosures before the Office of Special Counsel or an Inspector General. So for instance, if an employee is called as a witness in an Office of Special Counsel investigation and their agency finds out about their participation in the investigation and then begins to take adverse personnel actions, for instance, a lowered performance appraisal rating, that would fall under this particular type of protected activity. The final category of protected activity is refusing to obey an order that would violate a law. So those are the general 5 categories of protected activity. Now let's go back to the first one, retaliation for whistleblowing. What is that? Well, essentially, there are 6 categories of the types of whistleblowing an employee may engage under the Whistleblower Protection Act. The first category is a violation of law, rule, or regulation, gross mismanagement, gross waste of funds, an abuse of authority, a substantial and specific danger to public health or safety, and the last is censorship related to scientific research. So those are the types of information that's defined as whistleblowing. An employee must have a reasonable belief that they're engaging in one of those 5 areas of whistleblowing. Now, this also involves an area, protected whistleblowing, that has 4 elements to prove. We've just discussed the first element. That is, the employee has engaged in protected whistleblowing. The second element is that there be a personnel action, either taken or threatened. The third element is that there be knowledge. The employing agency, the supervisor, must have knowledge that the employee engaged in that protected whistleblowing. And the fourth element is that the disclosure, the protected whistleblowing, has to be a contributing factor in any adverse personnel action that's taken or threatened. And contributing factor can be any factor. One thing to keep in mind when we go through the categories of protected whistleblowing is that there are certain types of disclosures that can't be made to just anyone. For instance, classified information. It's important to note that there are protected channels for disclosing classified information. For instance, the Office of Special Counsel or the Inspector General of an agency where an employee is employed. A few additional points that might not be obvious. There is no chain of command that's required for an employee to make a protected disclosure or engage in whistleblowing. Also, employees who are perceived whistleblowers are also protected. So for instance, if my supervisor believes that I am the whistleblower when in fact it's my friend and colleague Joe who's the whistleblower, I may still be protected from retaliation for whistleblowing. Now I'd like to talk briefly about the type of remedies that the Office of Special Counsel can seek for retaliation for whistleblowing cases. In general, the remedies include what's called status quo ante, placing the employee back in the position he or she would have been had the retaliation not occurred. So for instance, if the employee alleges that they received a 30-day suspension for engaging in protected whistleblowing, and the Office of Special Counsel is able to prove that case, we can seek the reimbursement for the salary for the 30-day suspension. We can have that suspension removed from the employee's record. Attorney's fees are also something that the Office of Special Counsel may seek damages for. Lastly, in certain cases, the Office of Special Counsel may seek compensatory damages. Those are damages that are not out-of-pocket costs. Those are damages for things like emotional pain and suffering. In addition to what I would call those corrective action type remedies that the Office of Special Counsel may seek, the Office of Special Counsel also may seek disciplinary action against the official who's accused of retaliating against the employee. That could be anything from a letter of reprimand all the way through dismissal. Most of the cases brought before the Office of Special Counsel where evidence is sufficient to prove retaliation are solved through negotiation with the agency. But there are processes through filing complaints with the Merit Systems Protection Board, which we may also use if we are unsuccessful in negotiating a case. There are 2 accompanying videos that give details on both the other 11 prohibited personnel practices as well as the process by which one can file an OSC complaint, which you may want to use, as well as reviewing our website. I hope this video has been helpful.